Hi everyone, this is attorney Simon Budwani from Core Law Group, and this is hashtag Your Legal Minute. Actually, today's video is going to be a bit longer. These are unprecedented times that warrant an extra minute or two or five to this video given the current COVID-19 pandemic we are all dealing with. I am reaching out to you today because over the last week, my team and I have been inundated with questions regarding custody and visitation issues related to what's going on in the world with COVID-19. The most common question, which I will do my best to answer today, is this: whether or not you, as a parent, are required to follow existing child custody and visitation orders, even though the state of California has made safe at home orders that require the public, for the most part, to stay at home. In other words, the question is, do you currently have to comply with custody and visitation exchange orders given the circumstances? As a family law practitioner, my opinion is that as a parent, you currently, as a matter of law, are required to comply with custody and visitation orders that do exist, unless there are new orders that supersede the prior orders, or if doing so would not be in the best interest of your children. That last exception regarding the children's best interest is the one that is causing disagreements between parents and making my phone and text messages go crazy. Parents today are disagreeing on whether it's safe to continue with custody exchanges under the current circumstances, and understandably so. As a parent, after all, it is your responsibility to protect your kids. But before you pull the trigger and withhold visitation, or on the other hand, demand that the other parent complies with visitation, make sure you understand the standard the court will likely use to determine if your conduct was reasonable or not. That standard is called the best interest standard. The standard is written in the California Family Code, which overall governs these issues. That code, under section 3020, emphasizes how important it is for the court to take into account the best interest of the children when making orders about custody and visitation. It requires that the court ensure that the health, safety, and welfare of the children are maintained. Now, why is this code so important? I believe it's important because, one, if the court ultimately finds that you were wrong to deviate from its custody and visitation orders, it could use this section of the law to modify your custody and visitation in the future, to take it away. I also believe this code not only applies to the court, but it also applies to parents themselves. When this pandemic is over, and as the California courts reopen, I believe our family court judges will hold parents accountable to this very standard. The courts will ask whether your conduct in deviating from its custody and visitation orders was reasonable and done in the best interest of your children. So, I guess here's the million-dollar question. What would I do? I would comply with the current court orders unless I was absolutely sure that they would negatively affect the health, safety, or welfare of my kids. As a side note, remember, these judges have seen it all. They will probably see through any BS excuses you or anyone else comes up with when arguing that visitation was not in the children's best interest. So I caution you. I caution you to answer that question honestly with yourself before you deviate from any of the court's current orders. Okay, back to the question at hand. What would I do? I would comply unless law enforcement indicates otherwise. I would comply unless a new order by the government or the court excuses my non-compliance or supersedes the prior court order. I would comply unless the children or a family member in either household is exhibiting symptoms of COVID-19 or has tested positive for it. As a practical matter, as a family law attorney, I encourage you to work with the other parent. I encourage you to do things like curbside exchanges from the car, if possible, to ensure that social distancing is maintained. I encourage you to utilize technology such as FaceTime and Zoom if physical exchanges are unsafe or not possible. I encourage you to be creative. I remind you that your children need both parents. One last tip, document everything in writing. Do your best to limit communications with the other parent to email, texts, apps like Talking Parents or Our Family Wizard. If you do talk over the phone, take notes. Maintain a diary, keep a journal. If you do end up in court, it's these documents that will become very important to help your case. As a lawyer, but more importantly as a parent, I'll leave you with this final thought. If there is ever a time to act selflessly for the best interest of our children, now is that time. If you or anyone else has questions, please feel free to email me or my team at family@corelawgroup.com. That's FAMILY@CORELAWGROUP.com. My team and I will do our best to respond to your questions as soon as we can. Be well, be safe, and I almost forgot. This is Simon Budwani, and this has been #YourLegalMinute, or in this case, 5 minutes.